Namaste and greetings. I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, Prabhav एवं नीति अनुसंधान संस्थान नई दिल्ली, extend my warmest welcome to you all to IMPRI #Web Policy Learning. Today we are gathered here for day 12 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course, and internship program. This program is organized by the IMPRI, Impact and Policy Research Institute, New Delhi. The chair for the program is Professor Vibhuti Patel, visiting distinguished professor at IMPRI, and the fellowship lead advisor and expert legal hands-on sessions is Advocate Dr. Shalu Nigam, visiting senior fellow, IMPRI. The distinguished experts include Sri Sandeep Chachra, Professor Vibhuti Patel, Advocate Dr. Shalu Nigam, Advocate Dr. Wahida Nainar, Professor Mukul Ashar, Professor Uday Shankar, Sri Udit Mishra, Dr. Nivedita P. Haran, Sri Bhartendra Singh Baswan, Advocate Dr. Albertina Almeida, Dr. Punima Chauhan, Dr. Gladstone Xavier, Professor Aruna Roy, Advocate Audrey D. Mello, Dr. Kaustav K. Bandyopadhyay, Advocate Munalini Deshmukh, Professor Sharmila Ghuge, Advocate Flavia Agnes, Dr. Rashmi Singh, Mr. Devaditya Sinha, Professor Swaran Singh, Advocate Lara Jasani, Professor Anil K. Gupta, Justice Ajit K. Singh, Mr. Himanshu Shekhar, Dr. Amar Jasani, Dr. Soumyadip Chattopadhyay, Mr. Bilal Khan, Sri Rajiv Ranjan Singh, Sri Tikender Singh Panwar, Sri Shailesh Gandhi, Dr. Simi Mehta, Advocate Abdul Hafiz Gandhi, Professor Amida Singh, Dr. Ajay Gudavarti, Sri Amit Dubey, Professor Sangamitra Acharya, Dr. Y. Suresh Reddy, Advocate Sanchita N, Sri Surendranath Tripathi. The conveners for this course are Dr. Simi Mehta, CEO and Editorial Director at IMPRI, Advocate Dr. Shalu Nigam, Visiting Senior Fellow IMPRI, and Dr. Arjun Kumar, Director at IMPRI. I welcome you all to this enlightening deliberation and thank you for putting your time, effort, and energy into truly understanding the vital role and complex intricacies of legal and public policy frameworks. We have also shared the course outline and reading resource document in your email for your kind perusal. We will be providing videos of each session for flexible learning at your place and place. Before we start today's session, I would like to announce the housekeeping rules. It is imperative that you join the meeting on time. Second, there will be a Q&A session after each presentation. Third, share your questions in the Q&A box and not in the chat box. Fourth, the questions must not be posted as an anonymous attendee. Fifth, ensure that your questions are precise and refrain from making general comments in the questions to save time. Our session for day 12 will cover topics of women's rights and legislative reforms by Advocate Flavia Agnes. To start the session, I would like to invite Professor Vibhuti Patel for her opening chair remarks. Welcome, ma'am, and over to you.
Yeah. Thank you, Shweta, and thank you, Dr. Arjun Singh, Arjun Kumar, Dr. Simi Mehta, Dr. Shalu Nigam, Dr. and Ms. Vitita, Mr. Satyam Tripathi, and Nikita, the whole IMPRI team which has put this course together. And welcome Advocate Flavia Agnes and Dr. Rashmi Singh and esteemed participants. In this fourth week and the 12th day of this session, I would like to greet you and would like to give a brief summary of what has happened. In the first week, we also understood the macro issues about the law and public policy and the international human rights instruments. And then we, in the second week, policy initiatives and role of Indian judiciary, the boundaries of your judiciary, judicial activism were discussed, and what are the role of bureaucracy when it comes to law and public policy. That was also discussed with Dr. Nivedita Haran, who has worked as a IAS officer of Kerala State. In the third week, we had a question of, we deliberated the question of urban governance practices and how laws and policies, when creatively used, can give the better quality of life and the safety to urban population. The session on peace, conflict, and social work was by Dr. Gladstone Xavier, where he talked about how the social work as a discipline can contribute to peacekeeping, peacemaking, and peace building efforts at a grassroots level. And social security and law and public policy was debated by Professor Aruna Roy, in which she shared the experiences of Mazdoor Kisan Sangram Samiti in getting so many new laws like right to education, right to food, right to employment under MG Narega, and now they are fighting for urban employment also. And Mr. Nikhil, he also gave a very illuminating examples, case studies, and the achievements of the collective endeavor in Rajasthan. Advocate Albertina talked about how the inclusion, what kind of reservation policies, quotas, and inclusive approach we have within the laws and policies. And she gave several examples of Goa and rest of India, landmark judgments, and the cases which were taken up about discrimination, about atrocities and all. Now, Advocate Audrey de Mello's session on legal and social practice was whole journey of 40 years of Majlis of working on gender-based violence, domestic violence, and now their experiences in Manodharya and how they are working with the state and also maintaining their autonomy, and they are also building advocacy for a large-scale change in both laws as well as policies. Dr. Kaustubh Bandyopadhyay's experiences of PRIA, 40 years of activities of participatory research in Asia, where he talked about civil society laws and public policies and their impacts, and how we need to work we need to engage with the state and civil society need to engage. He also defined civil society in the Indian context and also gave a profile of the activities which civil society has done in the area of economic rights, social rights, human rights. And he said that if we need to, whatever social capital we have built, we need to we need to go back to that in these difficult times where fundings are short of supply. Like there is a tremendous shortage of funding which the NGO sector and civil society organizations are experiencing. Advocate Albertina's third lecture was also about the Goa Children's Act, and she gave the case study of the experiences with the judicial activism and also the grassroots organization, child rights organizations, and the processes that were involved in making this is the first unique law that we have in the state of India, in the state of Goa, and which many other states can also emulate to ensure safe childhood and dignity to children. And then we have Dr. Sharmila Guge, Professor Sharmila Guge, who spoke about the unresolved dilemma in the anticipatory bill to juvenile justice, to the juveniles under Juvenile Justice Act. And there was an animated discussion about who do we consider as a juvenile, and that whole controversial issue about the juvenile in the age group of 16 to 18, if they are involved in heinous crime, they should be treated, the amendment that we have, that they should be treated like adult. That also created a lot of controversy, and also the question of what do we consider as obscene and indecent when it comes to creative expression. About that also, there were so many unresolved issues. Even the word juvenile or delinquent, can we use the term delinquent, or and also the double standards we have when it comes to a girl, who we see as a child in need of protection and care, while when it comes to a boy, we always classify them either as a delinquent or as a child in conflict with the law. And now today, we are going to have equally animated, very interesting session about the law, society, and gender. Thank you.
Thank you, ma'am. We have Advocate Flavia Agnes, who will be taking up the session on the topic Women's Rights and Legislative Reforms. Advocate Flavia Agnes is a women's rights lawyer and the co-founder of Majlis Legal Center based in Mumbai. Welcome, ma'am, and over to you.
Thank you so much. Thank you, Vibhuti, for having me on this panel. I'm very happy to be here. This has been my main work, and I've written extensively on this, about the women's movement and how it has fought for legal changes and legislative reforms. So right from 1980, this has been the focus of every issue that is taken up by the women's movement. Firstly, the anti-rape law amendment to the rape law. In 1983, it came. and it widened the scope and brought in certain important changes in law, particularly increase in punishment, 7 years for ordinary rapes and 10 years for aggravated rapes, and also brought in a broader definition about rape, etc. So this was the beginning, and it provided a blueprint for us to follow in the years to come. And the government was receptive, and our demands were met at that time. But whether it brought changes on the ground is another question. And we still feel even today, the changes are not implemented at all. The second one was about dowry and dowry related legislation. So we got a new, in 84, the earlier dowry law was amended and the most stringent punishment was prescribed. And then in 1986, we got the amendment to IPC and brought in 498A. Now this 498A has become very controversial, and there is a lot of allegation that women are misusing it. But I believe that a lot of women don't even know this law, and they're not using this at all. But this law has the provision of immediate arrest. And that is what people are objecting to, that you file a false case and there is immediate arrest. So you have to run for anticipatory bail. So these are the general misgivings about this law. But according to me, it is a very small section of urban upper class women, but a large section of our rural women or even urban women from the lower class are not able to access justice. So there's so much of domestic violence there, but the very few cases of 498A actually filed. And now the police, even if you go to the police station, the police refused to file cases. So these are important changes in law that brought about. Then there is changes in the trafficking law, trafficking of minors, trafficking of children, etc. There's also similarly the punishment was increased, and also there is the Obscenities Prevention Act that was also introduced around this time. So basically, all the issues taken up by the women's movement ended in legislative reforms. Now, what did these reforms actually do? So mainly they made the law more deterrent. By deterrent, I mean increase in punishment. So the punishment was increased in every case that was taken up. And the law became very strict once a case is filed. But in most instances, the cases are never filed. So even in rape law, the cases are not filed. Now, the rape law went through many amendments, many changes over the years from 1983 onwards. And the more recent one is that after the so-called Nirbhaya case of Jyoti Pandey, again we got the law reform, and where certain clarifications have come that consent has to be voluntary. We can't just assume consent. Lack of protest is not consent. If somebody did not resist is not consent. And so now we have the 2013 amendment to the rape law, which came about after the recommendations by the Burma Committee. So this is where we stand today. But even today, it's not easy to file a rape case. And the procedure is very difficult. The earlier speakers must have spoken about the difficulties and challenges you meet in court. According to me, where the women's movement faltered was while stringent punishment was asked and the statutory reforms were got, but we didn't look at procedure. How does one access the courts? How do you go to court? What are the mechanisms into which access to justice is provided? So these issues did not get due attention at that time. But in the Domestic Violence Case Act, the whole procedure has been made a lot of attention has been introduced, and particularly regarding the statute, regarding the procedure. So this, with this, you have several sections. You don't need a lawyer. A very wide definition of domestic violence is provided: verbal violence, economic violence, physical violence, sexual violence, etc. has come into it. And there's certain protection. It's not just criminalization, but it is protective legislation that if you file under this act, you can ask for civil remedies. So it's a criminal act, but also civil act. So here the remedies are that you have a right to stay in the matrimonial home, custody of children, maintenance, etc., which were there in different personal laws, but they've all come together in the Domestic Violence Act. So here it is the wide definition using abusive language, physical assault, of course, sexual assault, of course, but even other things like throwing her out of the house, using abusive language. All of them have been made offenses, and you can ask for remedy, and you can ask for civil remedy. So this has been extremely useful, and this has been extremely useful, and a lot of people are using this. Not sufficient people, but at least the preventive action has helped a lot. So this is the Domestic Violence Act, which came in 2005. And a simple application to the court is sufficient. And the format is given in the act itself. You don't need a lawyer. An NGO person can also represent you. And so the expenses of spending on a lawyer is cut out. And you can get immediate remedy. This is all on paper. Actually, when you go to court, it is as difficult, but maybe slightly easier than before. Rather than going to police station and filing a criminal complaint, you can directly go to court with a simple application, either yourself or helped by an NGO or helped by a legal aid lawyer, etc. And just mention the instances of violence and take secure protection. This is not a law which gives you a divorce, but it gives you other protective measures. So this is important of the Domestic Violence Act. And the women's movement had to struggle for nearly 2 decades to get this act, because it is so complicated. It is a combination of civil and criminal remedies. And so we are greatly benefited by this act. I don't know, other speakers may have spoken about it, but I also feel that it is of great importance that this act has come about in 2005. Now we are in 2023, but even then a lot of people are not aware of it. So this is the Domestic Violence Act. And if you study this act, then in the procedure, which is given very simply and very easily understandable language is used here. And that is the benefit of this particular act. So we are very happy with this act. Of course, the magistrates, it is supposed to be very short, within a short time you have to get your remedies. But the courts are overclocked and long dates are given. So it is not being implemented as it was originally envisaged. But even then, it is better situation than earlier, because you go to magistrate court, you don't go to civil court. Civil court is more expensive. Magistrate court is simpler. Application is also simple. NGOs can also file, legal aid lawyer can also represent you. So the litigation cost is reduced and the simple procedure helps you. So Majlis has been using this law a lot, particularly for women who are coming. Most women who come are in an abusive marriage situation. There's a lot of domestic violence there. And instead of filing straight away for divorce, we file under this act and ask for maintenance or custody, or most important, right of residence, that he cannot threaten her to throw her out. So this is the Domestic Violence Act. But I just want to say a little bit on the question of Uniform Civil Code. Now we have a Uniform Civil Code issue, which is simmering. And the Law Commission in 2018 brought out a report. That is the 21st Law Commission, which said that a uniform civil code is neither necessary nor required at this stage. But they made a lot of recommendations to make personal laws gender just, equitable. I agree that personal laws have a lot of discrimination against women. They are feudal in nature, and women are given a subordinate position. So I'm not defending the gender unjust laws. I'm only pointing out the mechanism into which we can rectify this without going into this whole debate or controversy regarding the Uniform Civil Code. This happened in 2018, August 31st. The report was brought out by the 21st Law Commission. But in last month, in June 14th, the 22nd Law Commission again asked for opinions on the Uniform Civil Code. And our Prime Minister, when we're speaking in Bhopal to the grassroots workers, he made a plea for the Uniform Civil Code. Now, what is our objection? Our objection is that the entire focus here is anti-Muslim. The entire focus is to divide the community. The entire focus is to control population. So take out polygamy. I'm not saying any of them should be allowed. I'm only saying that by doing this in this manner, just before the election, the political intention becomes very clear. It's not just a question of legal rights or women's rights. There's also a political agenda beneath this. I'm saying this because all the experts, many experts have said this also. The 2018 report had lots of suggestions, small suggestions to make the law gender equitable, to bring in, take out discrimination and to make it gender just. In 2018 to 2023, the government did not bring in a single amendment. And that is very sad part of it. And suddenly they woke up and said, now we need Uniform Civil Code to bring in gender justice. So the PM's talk is entirely on Muslim community and saying that the Muslim law is backward, Muslim community is backward, and vested interests are influencing the Muslim community leaders against the Uniform Civil Code, etc. Thereby implying that everything is perfect with the Hindu law, and Hindu law is progressive. Now, this whole one law, one nation theory, according to me, is very detrimental. There is a fear among the minorities that is going towards building one nation, one law, towards building a Hindu Rashtra. So what is when we say Law Commission is asking for opinion, the 22nd Law Commission, the Law Commission has not introduced a draft at all. They are working on it, in fact, but in one stroke to take out all personal laws is not feasible in our country. There are so many tribal cultures who are following their own religion. And if there is a lot of opposition to it, it will not be agreed upon by minorities as well as by these communities or the states, entire states who have exemption, constitutional exemption under 371, for instance, 371A, 371G, etc., where the personal laws are preserved. And there is a local council which has to approve. Just because the center is brought in law, it does not apply to them. And already there is unrest. Already people have said that the entire state is said, like Mizoram, Nagaland, saying that you are interfering with the tribal customs. Now, are there tribal customs gender just? Some have matrilineal traditions, some are patriarchal, some uphold women's rights, and some don't. But is this the way to go about it? Is this the easy way out of the situation? So this is problematic. And this is why Majlis has worked very strongly, feels very strongly about this. And we have collected a lot of signatures and a lot of people are opposed to this, and this entire thing is going to be sent to the law minister or the law commission very soon, like in a day or two, and will be sent out with all the signatures of people, of informed people, of people who are well aware of it. The judges there who have endorsed, a lot of legal experts have enforced, and we are in the process of finalizing this. So this is our concern today, that uniform law will divide the community. The objection here is the entire slogan one nation, one law. And that law is, there's a fear it will be a Hindu law, and it will go towards building the Hindu Rashtra. There's also this whole concern that Muslim polygamy is increasing population of Muslims, and Muslims will soon overtake Hindus. This is another fear among the people which is whipped up. And here the Hindus are about 80%. Muslims are around 14%. So it's kind of absurd that Muslim population, if there is no UCC, Muslim population will overtake the Hindu population. It's just absurd connotation, but Hindus get very easily swayed by it. And that's why they endorse the UCC. In fact, there is active campaign, and a letter has been circulated saying that a draft is circulated. I support the UCC because of this, because of this, because of this. I also have received this. And there are adverse propaganda material that are being circulated. And the Law Commission has said that they have received about 20 lakh responses. So how do these responses come? From where do these responses come? Who's manipulating this? So this is some real concern. And if the Prime Minister's spitted for this, and the Law Commission is also going to be a so-called opinion of the people, etc. So it is sort of imminent that they're saying that in the monsoon session only a draft will be submitted, etc. Right now we are asking, Law Commission is asking for opinion without a draft. There's nothing to respond to. And so legal experts have said you don't have to respond because nothing to respond to. But if you don't respond, then they'll say you agree. So in order to show your opposition, there has to be a letter written to the Law Commission, oppose that you are opposing this. So this is where we stand. And so I've covered issues like the legislative reforms of the 80s, and more recently the Rape Amendment, etc. I've also covered the issue of Domestic Violence Act, how it has helped, which has got both criminal and civil remedies, and it is easier to access the courts. And I've also touched upon the Uniform Civil Code and our resistance to that, our opposition to that, and how it is important to express our opinion and write letters to the Law Commission. This time is very less. They have given 1 month from the 14th of July. So by 13th of July, your reply has to go. So I urge all of you to write to Law Commission and express your opinion and say that you, if you really believe in what I say you oppose the Domestic Violence Act, the Uniform Civil Code, and you will support the 21st Law Commission report and agree to changes within personal laws. It's my request to you. If you have any questions, I will answer them.
Yes, thank you, ma'am, for such an enlightening and insightful session. Now I request the Chair, Professor Vibhuti, to share her remarks.
Issues you have raised. I have two questions. One is about population, and also I think the role of caste panchayats. We all have 30,000 customary laws, and as per the Schedule 5 of the Constitution of India, we have 645 distinct tribes in our country. So when they say that northeastern states will be consulted before any legal reforms in customary or uniform civil. But what about that? We have tribal population throughout the country. Plus, we have khap panchayats and we have caste panchayats. How will they this thing come under the purview of UCC? Because some of the caste panchayats are extremely powerful in Haryana, Rajasthan, Punjab, even Gujarat. So how would they reconcile with the Uniform Civil Code, the leaders of the caste panchayats?
See, nothing is known right now. And I agree with you. The local tribes and their caste panchayats and tribal formations are very, very strong.
Yeah.
And they're also not gender just. There's a lot of injustice to women happening there.
Yeah.
So we need to address that.
Yeah.
The government has to work very concretely in addressing such discrimination against women.
Yeah.
So how the UCC is going to help that, I am not aware because we don't have a draft. So how it will be implemented and what is the mechanism through which it will be brought about, that is not known today. And I agree with you that Hindu law itself, when the Hindu Code bill was passed, it gave exemption to customary practices for marriage and for divorce, for polygamy also. So if your custom accepts, then the court also said the custom accepts it, the tribal custom or caste concern. Even your marriage situation is either is a Brahminical or based on caste. So either it is you have to do Saptapadi, the 7 feras round fire and Kanyadan, or you have to follow the tribal custom. So now in such a situation that you bring in a uniform civil code, who is going to follow this? And one point I missed is the Hindu undivided family property, where women are not given property rights. Now recently there have been some amendments to this, but even then the girls are forced to give their signature and give the property to the brother at the time of the marriage itself. And they are told that you are given dowry, so now you don't have property rights. So this is the system. So how are we going to tackle this?
Yeah.
And how the Uniform Civil Code is going to tackle this? These are some important questions that we need to address.
Yeah. I think even that's why I think even among the Indians, it's not only Muslims question, because yesterday also it came out that even in northeastern countries, even after 40 years of efforts by feminists like Jarjum, they said we could not bring reforms in the polygamy. It is rampant, even in her state, no, Arunachal Pradesh. And other thing is that when it comes to officials in certain states have circulated GR requesting brothers not to allow their sisters to tie Rakhi unless they gave it in writing that they don't want sharing property. Imagine an official GR was sent last year at the time of Rakhi in Rajasthan. Later on, it was withdrawn after the protest and all. But this is the level of patriarchal control, no, over women's entitlements. No? Yeah. So it's going to create a lot of problem now. It's not only among the Muslims, but I think other communities and other religious groups are also going to be very, very, what you call, insecure. And also, we haven't seen their statements, but I think there must be a lot of churning going on amongst them also. Yeah.
So Jarjum was in support of the UCC?
No, she says that it's going to, the circumstance, they said during 80s, we were saying that we want gender just laws, family laws, but we know that how it is intertwined with the identity politics. And in current context, political context, it's going to be very detrimental. There should be reform from within. That communities should come out, no, and it is happening. She gave several examples of Arunachal Pradesh, where so many women, individual women, groups, State Commission for Women had also prepared a draft, which was, there was tremendous opposition from various tribal leaders, because all the tribal councils in Arunachal Pradesh are male dominated. They don't have women's representation. So they said this kind of debates and churning is going on in at a state level, no? But that should be like democratic process, people's involvement, opinion to switch on. You just can't impose it from center, no? That was the feeling, yeah. So reforms from within.
Thank you, ma'am. And I request Advocate Dr. Shalu Nigam to share her remarks.
Before that, I just want to say one thing.
Yeah.
I'd written this article in Indian Express a long time ago, just as this debate started. And I very strongly said that you bring in the reforms which the 2018 Law Commission, 21st Law Commission had recommended.
Correct.
And in 4 years, the government did not do anything at all. Now that, according to me, should be the way. While we agree that personal laws are patriarchal, they are framed in the feudal times, and they make women subordinates, and we need to change it. We need to bring newer values into this. But how the process? As I said, even about legislative reforms, the process is becoming very important rather than what outcome it is giving. So here also, it is very strongly felt that reform within community should come and not imposed from above a uniform law. So this is our concern here.
Yeah.
Thank you, ma'am.
Sorry.
Yeah.
Thank you for such an illuminating, your words. Like you have always been inspiration for people like me. That your work is like I've been reading all your articles and your books and other things. Just one thing, since you talked about domestic violence law and the rape law, but the manner in which it is implemented, because we all know that the problems women face in access to justice, but by the time the court the cases reach to the High Court or to the Supreme Court, what we have seen is that sometimes you get a very kind of anti-women kind of judgments where the High Courts have said, okay, the rapist can should be tied Rakhi, and if the victim and the accused are getting married, they could be, the case could be resolved, or maybe the Anish Kumar judgments, which talks about the women are liars and all the cases are false and something like that. So how to deal with this kind of, and even the Home Ministry have issued a lot of notifications time to time about diluting these kind of laws, especially the 498. And we have seen that Dowry law is not yet being implemented at the ground level. It's there on the paper for so many decades, but not being implemented. So how should we proceed in that direction? So since you a lot of efforts have been made to make these laws, and now we are seeing that phase that these laws are getting implemented in the court. So how should we proceed about that?
I agree with you a lot. There's supposed to be judicial academies and a lot of training for judges. Starts right at the Supreme Court level to High Court level to Sessions Court judges, etc. But the thing is, it doesn't work because there is no monitoring once the training is given. And sometimes the trainers themselves are very patriarchal in their viewpoint. Particularly if I say something and a Supreme Court judge says something else against what I have said, then the judges are likely to accept what the Supreme Court judge says because that's their training, their superiors, etc. And I'm an outsider. So my saying something has no value. So this is where we are stuck. And particularly an adverse judgment has come, then it becomes very popular. Even the newspapers discuss it. Everybody is aware of it. Adverse publicity is given. So all the judges know about it. The positive aspects, they don't know because it's never been talked about in the press. So that is the difficulty in which we are facing. And according to me, only positive judgments of the High Court and Supreme Court will matter. And only those can bring in changes. But if the negative judgments come in between, and then that wipes out all the gains. And that's where we are. And statutorily, how do you monitor the judges? There's no provision to monitor the judges at all because they have absolutely freedom to read the law, assess the facts, and give their judgment. They have to be free thinking. So in that, women suffer. So legal awareness, according to me, is the only thing at the higher level of the judiciary. People, of course, at the lower level, NGOs, etc., need to be trained, but that is subsequent. The primary thing is to change the mindset of the judges so that negative judgments don't come.
Ma'am. So Nikita, back to you.
Thank you, ma'am. The floor is now open for questions from the audience. Meanwhile, I have a question, ma'am. With regard to UCC, since both the laws are very patriarchal in nature, so I would like you to elaborate on the 21st Law Commission report, like what measures were suggested to make these personal laws gender just.
You know, it looked, it's a very comprehensive report of 185 pages. It looked at all personal laws, particularly dealt with property rights, and talked about a Hindu undivided family property, and also discrimination under a Special Marriage Act, Parsi marriage, Christian marriage, all marriages. So, for instance, if a Parsi woman marries outside the community, she loses rights in a parental property. So they said such discrimination must go. Men and women should have equal rights to property inheritance. Similarly, the lots often I don't remember all of them, but the main point here was inheritance laws of the Hindus. The ratio of property must go. And I want to add to that, it was not said in the report because issues of bigamy and polygamy, etc., were before the Parliament or the Supreme Court. Adultery, 497, etc., were before the Supreme Court. So the Law Commission said, we will not address those because the Supreme Court or the Parliament can decide on this. But even so, we feel that that has to go. And then there are like many other about child custody, child guardianship, maintenance to women, inheritance, all uniform law should be there. Even among the Muslims, Shias and Sunnis have different laws. Among the Christians, if a widow doesn't have children, a childless widow gets only half the husband's property, the rest goes to husband's relative. So such things are there, very minute things are there in that report. And regarding adoption also, they said uniform laws should be applied, and some communities don't have adoption. So everybody should have equal rights of adopting children, as well as the custody issue at the time of divorce. And one important thing that the 2018 Law Commission report brought out is division of matrimonial property. This is very basic and important, because right now we have only right of maintenance for women at the time of divorce. And none of the personal laws have anything about division of matrimonial property. Now Majlis has been demanding this for a long time. And we also drafted a bill about division of matrimonial property. But it's such a complex issue. What happens to dowry? Who gets to keep it? What do we share? How much do we share? Do we share the matrimonial home? Do we share husband's share in the HUF property? All these questions came up, and it was very difficult to find an answer. We circulated that bill, and it was discussed also. But because of all these things, and the government changed, and the new commission came, so after that we did not pursue it. But this is what the Law Commission report says, 2018, and we need to follow this. So we need to see also in the UCC bill how they have dealt with this, that division of matrimonial property. It's not there in any personal law at the moment.
Thank you, ma'am. We'll now take up other questions. Kumari Dikshita has raised her hand. Please unmute yourself.
Yeah, ma'am, I have a doubt that regarding UCC implementation, even if the UCC demand is currently based on religion and against, increasing Muslim population, but isn't it good for women's rights plus gender justice, etc.? Because if we register our protest against it right now, kind of demand will emerge in the future, because often we hear that it is better, to strike out when the iron is hot. So what you have, want to say about that?
Can you just repeat, please?
Ma'am, isn't it good for the women's rights and gender justice, etc., if the UCC is being implemented right now, even if we know that it is, right now its demand is totally dependent upon the religion and against Muslims increasing population?
Okay. See, but what are you agreeing for? You have no idea about it. So you are agreeing blindly that, yeah, I want uniform civil code. So, but are they going to touch the Hindu law? Are they going to do away with the joint property? Are they going to introduce matrimonial property? What are the principles upon which they will bring in all this? So these are the important concerns. What about child custody? Will single women get child custody? Yeah, adoption rights, etc. At the time of divorce, how do you separate? How do you find the child custody issue to be settled? So these are some of the important concerns for us. So we can't say blindly that it is good for women, and we need to look at it in more detail and find out where the problems are and how to solve them. I'm not saying they are good. I am saying that we need to address them separately, not necessarily going into the debate of UCC.
Shweta.
Ma'am, I have a question regarding how women's rights are impact in our neighboring countries. Now, for example, in the Middle East, we have the guardianship law in Saudi Arabia. And even the recent ban upliftment of women having rights to drive cars. So this reform, I think, or policy in place has impacted women's mobility and overall rights. So my question is how does this impact how does this impact the overall women's rights, like the guardianship law in Saudi Arabia with focus in India? So how does this impact?
I'm not very aware of this, of the Arab countries and how their laws are implemented. My work is here only, and I have only dealt with the Indian laws. And here, according to me, are the problem areas, and we need to address them as they come up here in our situation. So there have been changes in the Muslim personal law, for instance. 1986, the right upon divorce. More recently, the law legislation that was brought up in 2022, where right upon marriage has been brought in for Muslims. So, and if a husband gives talaq, he can be imprisoned. So these are some of the laws that have come up in India. So I like, for instance, to give you a simple example, in Karnataka, women's travel is free. And that has liberated women so much that they can go anywhere in the bus ride, and there are no ticket for them. So simple. Instead of going to like Saudi Arabia, you can just go here in India and see what are the advantages. Simple thing, nothing to do with law, but the government policy. So how this policy actually helped women's mobility and their ability to travel. So these are like very simple things that can help at the policy level, grant women freedom of movement. So we have such things we have to look at and support them as policy level decisions, which will strengthen women's empowerment. We're talking about Saudi Arabia and the women's, given the women to drive, but I'm talking about simple bus travel in India. So these are, we need to look at policy level, how it has impacted gender. So not only personal laws, but even other policy level decisions are impacting women's empowerment generally.
Also, ma'am, I mean, in hindsight, for which states in India can we sort of look for a more progressive women rights for policy changes and so on and so forth? Which states in India can we anticipate such progressive women's rights?
Well, mostly we have dealt with central legislations. State-wise legislations we have not gone into. And all I know is that tribal communities and certain states like Nagaland and Mizoram have objected to the Uniform Civil Code. But otherwise, I don't know which state, but you have to look at the state-wise index of women's empowerment, and maybe Vibhuti can pitch in here to say which state is better. But there's a general feeling that North Indian states tend to be more patriarchal than South Indian states. South Indian states give more empowerment to women and women's mobility. This much is a very general statement, but state-wise, we need to see, look, different parameters are there, like dowry death cases, 498A cases, divorce cases, whether they have property rights, whether they're accessing more property rights. And these things we need to look at.
Over and above what Flavia has said, I think there are other indicators also, like participation in electoral bodies and position like Pradhan and Mayor and all. So from that point of view, I think Kerala is the best. Kerala, Tamil Nadu, Karnataka, Telangana, and Andhra Pradesh. They are much ahead. When it comes to even Goa, when it comes to progressive laws, especially at the ground level, as Goa is the only state where you have a Goa Children's Act, no, which is so important. So that is there. Another thing is that utilization of government funds, whatever is gender responsive budgeting, to reduce the gender gap in 5 areas of education, health, employment, political participation, and combating gender-based violence. In that also, certain states have a better record. And when it comes to Nirbhaya Fund, it is northeastern states which are excellent, because there are states after states and union territories. There is 100% non-utilization. In fact, there is a very comprehensive article in Sunday Review which shows the state-wise how much utilization has taken place. So from 2013, we have 1,000 crore rupees allocated to combat gender-based violence, but states have not sent proposals. So that is a major this thing. So political arena, when it comes to the educational profile also, women in beyond arts and science, no, like BA, BCom, say beyond professional courses, there also you see parents spending money on daughters' professional education. Even those indicators, they are better in the states below Vindhyachal. Those who are above Vindhyachal, even the middle class and upper class, it is said that they will be very hospitable. They may give you one big glass of lassi, as one bureaucrat said, free of charge if you go as a hospitality. But ask them to pay 30 rupees fees for daughters' education, they will not. And so I think that this kind of a cultural differences, where value of daughter, that is much more found in the Western India and not Rajasthan, but at least Gujarat, Maharashtra, and the southern states. But now Human Development Report 2002 and Human Development Report 2012, both of them have given this gender development index, gender empowerment measure, they call it GEM. So GEM are also given state-wise according to all these criteria of these 5 important gaps. No?
Thank you, ma'am. I have 2 questions. First, what is the reason behind this difference among the southern part of the states and the northern part of the states? The value of the daughter is more below the Vindhyachal, as you mentioned. And other question is, the violence against women is pervasive across the country, be it sexual violence, domestic violence, or physical violence. So how can we curb it? How can we address the root cause of the problem? Like we always say that the root cause is patriarchy. So how do we actually transition that mind from changing the mindset of people? How to actually address it in
Vibhuti, you want to answer this?
Yes, I want to answer. First answer is there are ethnographers, anthropologists, historians who have written extensively on why this much of cultural difference. First, they say that northern states had experience for invasion by the foreign rulers throughout, like the last 1200 years, while southern states, they went up to Vindhyachal. Southern states never experienced invasion of foreign rules, and that is why the question of segregation of women, custom of parda, killing of daughters, female infanticide, this is not the cultural legacy which Dravid culture had. And it is also Aryan. Aryan culture was very extremely influential in the northern states, which was not the case for northeast as well as southern states. So culturally, that is the legacy. Like there was never like covering the head or segregating women not going out, or these kind of things were historically not there. Caste system was there, but the segregation of women into domesticity and the parda and no role in public life, that has not been the historical legacy of certain states. So it's a Dravid culture also, which was far more egalitarian than the Aryan culture. So that is one explanation they have. And then second question was about, what was your question? Hello?
How do we actually bring about the change in mindset?
Correct. So patriarchy operates differently in a different socio-cultural context, no? So you have to have a specific understanding of patriarchy, the way Aruna Roy and Nikhil they explained the case of Rajasthan. In Rajasthan, what are the cultural legacy? What are the most important issues of female infanticide or abandonment of this thing, or in the name of culture, inducting them into sex work and all. So knowing the local problem and the level of subordination and the control over women's sexuality, fertility, labor, you have to create your intervention strategy in collaboration with the people. So you can't have one particular, we need central legislations, but at the same time, we also need a specific intervention. Why do we have witch killing only in 14 states? It's not there in all Indian states. Women being dubbed as a witch and killed. So then you have to have anti-witchcraft law in that particular witch hunting law in the areas where such practices are going on, where you have a very strong institutionalized untouchability. Then you have to make Atrocities Act far more sharper and see to it that it is implemented. So I think specificity, knowing the geographical location and the historical legacy and the cultural practices of people, we have to come. Like crimes in the name of honor, they are not happening everywhere. There are certain pockets where when the young lovers, they fall in love with each other, they are being killed by their own family members. So I think we need to address the issue knowing the local reality and come up with a specific intervention strategy.
And the honor killings, for instance, happens in many ways. One is intercaste, intercommunity, interreligion. Secondly, the norms of not marrying a close relative.
Correct.
Sapinda or 3 generations, etc. And if you fall in love with somebody close relative, like a brother, assumed to be brother, and then again there is honor killing on this. So we have to understand this culture and traditions. And we have to also look whether in the south you have any of these killings or it's only in the certain northern states. So all these are indicators for us to understand the status of the girl child or the status of women in these areas. And as we all know that particularly North Indian states are very anti-women, more patriarchal in their approach towards women. And hence the infant killing, girl child, finding out the fetus of the girl child and about leading to abortion. Most of these practices prevail to a very high degree in North India and not so much in Gujarat. Gujarat is there, but suicides by married women, etc. But Maharashtra and the southern states.
Yeah. No, but the problem is that even among the warrior caste, like the highest number of caste, if you see NCRB data, highest number of intercaste marriages in which people are killed is in Tamil Nadu. And that is among the warrior caste, certain warrior caste, this thing. And now increasingly the children in schools and colleges and workplaces are meeting each other, no? So intercaste marriages are also increasing in number. and the atrocity is also increasing. So because there is more freedom to women wherever they are, and they are also taking their own decisions, no? So that is also there. But mostly it is the warrior caste, Jats, Rajputs, this thing, where this question of endogamy is so pronounced. And elite also, because it is also linked with the concentration and centralization of property and assets. So if your daughter marries outside, then it is going to create division in the property. In fact, that's what was told when we did the survey on sex selective abortion. It was in like southern Bombay, South Bombay, which did not want a single girl. There were nursing homes in South Bombay had an extremely adverse child sex ratio at birth. So the nursing home, there were 1,011 children, boys, 2,000 girls. So that was the level of skewedness. And when we asked the super rich people in Mumbai, they said, we don't want any daughter because our Jawai will ask for share in property. And we have built our empire with 40, 50 years of sweat and blood, which we don't want to give to. And even the name will change. If it is now, say, Trivedi, it may become Shah after our son-in-law demands the share in property. So there are so many economic, social, cultural, historical reasons which also determine our practices, tradition, customs, and actual practices. Yeah.
Thank you, ma'am, for the fruitful discussion. With the chair's permission, we can go for the vote of thanks.
Yeah, please.
I
Can also
Yeah,
go
please go ahead. Please go ahead.
for closing remarks by Professor Patel.
Yeah. So I think today all three issues which Flavia has raised, one is about the work on the gender-based violence, which has been a long drawn struggle from 1980 till now. And there also, I fully endorse that laws have become stricter, but implementation is a very important, very major challenge that people are facing at a grassroots level. And second, 498A, when men's organizations have the Pati Bachao Manch and all, they are also creating the lobbies. There are several judgments in which judges have made very adverse statement about 498A. But if you go through the data and the studies which Majlis has done, which shows that hardly 2% of people have been punished under 498A. So that is also very important concern. When it comes to judges training, what Flavia said is that the remarks which judges are making, and especially after that Madhya Pradesh High Court judge, who had asked the rapist to marry the minor girl when she becomes that created a major uproar. And after that, the Achar Samhita, code of conduct for judges, what type of language to use, what words to use, what terminologies to use, that also Supreme Court had come up with. I think about that is not much publicity. It happened during the lockdown, but I think we need to publicize this code of conduct for the judges, which Supreme Court has prepared. No, that is very important. And the question of uniform civil code, I think it's the democratic processes are very important. And Flavia is right when she said that 2018 the Law Commission, 21st Law Commission had involved women's groups. There were comprehensive suggestions were given by the women's rights organization, lawyers, and the process was far more participatory than suddenly. And now even we don't even have a draft. What the government is talking of UCC, where they have not even put the draft of the UCC. They have asked people's suggestion, but without any base document. Even it is not that itself shows that how serious they are about this issue. And I think it is not a Hindu versus Muslim issue. It is a question of so many caste groups and community organizations, 650 tribal groups in our country who are minorities like Christians and the Buddhist and the Sikhs. They are also feeling quite insecure about what's going to happen when you have this whole UCC backed by one Rashtra, one law, one nation formula. No? So I think it's a very enlightening session we have had. And I think IMPRI has also circulated YouTube. So I think it is going to reach to thousands of people. Already it is in circulation. The current debate is in circulation.
Thank you, ma'am.
Yeah.
So we can go for the vote of thanks now.
Permission of chair, can I just just a small request. I just
Yeah.
want to make, since ma'am has, views about marital rape, under the question of law.
Yeah.
And that is very important issue that we like, somehow we have skipped it, during our whole course. So
Correct.
just, just quickly give your views regarding that.
Yeah.
With the permission of Chair.
Yeah,
So-
yeah, please go ahead. But DV Act takes care of it. Yeah, but Flavia, please. Yeah.
I agree that is a very pressing issue. We have not legislated upon it. Every time it has come up, there have been like barriers that are thrown up. And finally, there's also the whole question if 498 is causing so much distress, then this bringing in marital rape will wreck families and etc. etc. There are all kind of fears that are being thrown out. So many times it has come before the legislature, also before the Supreme Court also, but this exception to husbands to have free sexual access to the wife should be taken out, and whether the consent is necessary. Now, there are judgments of the High Court and Supreme Court where they've said not having sex with your wife, not having sex with the husband causes domestic violence, and on that ground they have given divorce to the husband. So you wonder where you stand regarding the marital rape issue, and there is no consensus here. But I agree with you that we need to look at it very seriously, and we need to bring in the suitable legislation to take away the exception given to husbands that after marriage he has free access to the wife. Her consent should be the primary importance, and he cannot force himself upon her. And such judgment should go. There cannot be such judgments on this issue. It's going to cause a lot of churning. It's going to cause a lot of distress. And again, women are filing false cases. How do you prove, etc., etc. And when do you give consent? When do you withdraw consent, etc.? Are issues that are coming up or will be raised once this exception is taken out. But even so, the challenges we have to face. But this issue, this exemption must be taken out for the male under Section 376 of the rape law.
Thank you, ma'am. I guess there are no further questions, so we can go to the vote of thanks.
Please go ahead. Yeah.
As we come to the end of day 12 of the Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course and internship program, I, Nikita Bhardwaj, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our expert for the day 12 session, Advocate Flavia Agnes, for taking out her valuable time and giving us an opportunity to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel, and lead advisor, Advocate Dr. Shalu Nigam, for convening the session. We thank all of our participants who have raised pertinent questions and actively participated in today's celebration. We look forward to welcoming you Wednesday, that is 12th July at 11:30 a.m. for our 13th day of the certification course by distinguished experts, Mr. Devaditya Sinha, Professor Swaran Singh, and Advocate Dr. Shalu Nigam. We are grateful if you are watching us later on YouTube or listening to us on our various podcasts or reading our publications. We hope you continue to join in future to our IMPRI #Web Policy Talk and #Web Policy Learning. Wishing you a good day. Thank you.
Thank you. Thank you, everyone. Have a
Bye.
nice day.
Thank you.